Quick update out of Crazy Town, everyone, or also known as the Southern District of New York, federal court. We've been having this issue going on with the mayor of New York City, Eric Adams, who has been indicted by a grand jury for bribery and corruption. Now, Mr. Bove, or number 2 in the Department of Justice, said, well, we need to dismiss this case because we need Mr. Adams to go and help us with the persecution of immigrants. So he can't do that if he's worried about going to trial for bribery and corruption in April. So we need you to dismiss it. They were asking the federal prosecutors, and the federal prosecutors were saying, wow, I took an oath to the Constitution and I have ethics, so I can't just dismiss it for funsies. I need a legitimate reason. The Department of Justice said, well, we don't care. So those attorneys resigned. They popped it around to different places. A whole bunch of other attorneys resigned and said, well, we're not going to do a motion to dismiss. It's unethical. Ultimately, they found some schmuck to file a motion to dismiss in which Mr. Bove, number 2 in the Department of Justice, signed off on it. And they did this motion and said, we want to dismiss it. And so it went in front of Judge Ho. Now, I thought this had happened a couple weeks ago, but it actually had just occurred. Now we've got an order from Judge Ho, again, who's the one that ultimately decides whether or not to grant the motion to dismiss. And this order just came down out of New York. I'll just read it to you here. It's not very long, but it's quick to the point. On February 19th of 2025, the court held a conference on the government's motion to dismiss the indictment in this matter. Under Rule 48A, in light of the government's motion and the representations of the parties during the conference, it's clear that the trial in this matter will not go forward on April 21st. Accordingly, trial is adjourned sine die, which I know is not right. Is it sine die or sine die? Whatever, Latin terms for I'm not going to set a date. It's gonna just be put on pause with no date. That's what that is. The order setting a pretrial schedule is hereby vacated, and all deadlines set forth therein are also adjourned sine die. Sine die. Whatever. All right. SINEDIE. Normally, courts are aided in their decision-making through our system of adversarial testing, which can be particularly helpful in cases presenting unusual fact patterns or in cases of great public importance. Our legal system assumes that adversarial testing will ultimately advance the public interest in truth and fairness, citing case law. In particular, quote, the unique strength of our system of criminal justice is that it is premised on the belief that truth is best discovered by powerful statements on both sides of the equation. Citing for the case law, and we've got Young v. U.S. that he is quoting, the public interest that a result be reached which promotes a well-ordered society is foremost in every criminal proceeding. Our judgments are precedents, and the proper administration of the criminal law cannot be left merely to the stipulation of parties. So just because you both agree doesn't mean that's what we're going to do. For example, in the context of Rule 48A motion, the government's request for dismissal without prejudice is often contested by the defendant and then adjudicated by the court with the benefit of adversarial briefing, and then a string of cases are cited. Here, the recent conference helped clarify the parties' respective positions, but there has been no adversarial testing of the government's position generally or the form of its requested relief specifically. Whereas here, nominal adversaries are aligned in their positions, precedent and experience have recognized the authority of the courts to appoint an amicus to assist their decision-making. Amicus means friend, right? Including in criminal cases, and even when the movement is the government. Now, citing In re Flynn, quote, denying mandamus where district court appointed amicus counsel on unopposed Rule 48A motion. Indeed, the Supreme Court appoints an amicus to argue a case about once a year, often in situations where the government does not oppose the position advanced by its adversary. And then further case law is cited. The Dorsey case, noting appointment of amicus in criminal matters since petitioners and the government took the same position. The Second Circuit often does as well, citing case law further, noting arguments of court-appointed amicus. Similarly, district courts have broad discretion to permit or deny an appearance as amicus curiae in a case. which of course we know means friend of the court. And then he goes on to further cite some case law and explain what an amicus is. So, and there's precedent for the appointment of amicus to assist a district court in the consideration of an unopposed motion under Rule 48A specifically. This is page 3 of 5. Accordingly, to assist with its decision-making via an adversarial process, the court exercises its inherent authority to appoint Paul Clement of Clement and Murphy, PLLC, as amicus curiae to present arguments on the government's motion to dismiss. So the court's appointing a private person to come in and argue the position that the government would have here, because the government, technically the Department of Justice and Mr. Adams, are in agreement with this dismissal without prejudice. So the judge is like, whoa, we got to pull somebody else in. And he goes on further to cite case law, the Consumer Financial Protection Bureau out of 2020. Because the government agrees with the petitioner on the merits of the constitutional question, we appoint Paul Clement to defend the judgment below as amicus curiae. He has ably discharged his responsibility. The court expresses its gratitude to Mr. Clement for his service and will provide Mr. Clement a copy of this order and the transcript from February 19th conference. It is hereby ordered that the parties and amicus curiae shall address 1, the legal standard for leave to dismiss the indictment under Rule 48A, 2, whether and what extent a court may consider materials other than the Rule 48A motion itself, 3, under what circumstances, if any, additional procedural steps and or further inquiry would be appropriate before resolving a Rule 48 motion, and 4, under what circumstances, if leave is granted, dismissal should be with or without prejudice. That takes us to 5. If leave were denied under Rule 48A, what practical consequences would follow, including whether dismissal would nevertheless be appropriate or necessary under other rules or legal principles, for example, a necessary delay under Rule 48B, or under speedy trial principles, citing for the case law. And 6, any other issues the parties or amicus consider relevant to the court's resolution of the government's motion. Briefs shall be due no later than March 7th. If necessary, the court will hold oral argument at 2 p.m. on March 14th. The court notes that it has considered the parties' views with respect to the appointment of amicus and concludes that an appointment is appropriate here to assist the court decision-making. That is particularly so in light of the public importance of this case, which calls for careful deliberation. The court reiterates that it understands the importance of prompt resolution of the pending motion and will endeavor to rule expeditiously after briefing and, if necessary, oral argument is complete. The adjournment of trial and all related deadlines alleviates any prejudice resulting from a short delay. Moreover, in light of the concerns raised by the parties regarding the mayor's responsibilities and the burden of continued court appearances, the court notes that while Mayor Adams has a right to appear at any future proceedings, he does not do so given the current procedural posture. Quoting 43B3, stating a defendant need not be present where the proceeding involves only a conference or hearing on a question of law. In other words, absent an order of this court stating otherwise, Mayor Adams need not appear and need not file a notice voluntarily waiving his appearance at future proceedings, if any, on the government's motion to dismiss. Finally, in light of Mr. Clement's appointment as amicus, the court does not believe there is a need for additional amicus participation at this stage. Nevertheless, to ensure the parties are appointed and appointed amicus have an opportunity to respond to arguments made by other amici, if any motion for leave to participate as amicus must be filed with the proposed amicus brief by February 28th. The court will not consider any motions for amicus participation after that date. Any opposition to such a motion by a party shall be filed by March 5th of 2025. Signed, United States District Judge Ho on February 21st of 2025. So, an amicus has been appointed and briefs need to be put into the docket, and then we will see what happens from there, everyone.